The next
semināra satura tematisko
thematic
referentes piesaku
speech of
notāra
this seminar
Ilze
will be
Metuzale,
delivered by
kura
Ilze Metuzale, a notary in
ļoti
Riga.
bauda savu notāru darbu
She
un,
enjoys her
no viņas staro vieglums
work of a
un
notary
gaišums.
And
Un Ilze
light
pēc savas
and
pirmās
kindness
profesijas ir ērģelniece
radiates
un
from her.
muzikoloģe.
Her first profession is in organ playing and musicology. And assisting her sister in the sister's notary's office led her to notary studies and to becoming a notary. So now let us give the floor to Ilze, who's going to talk about characteristic features of succession law in the Baltic states, Austria and Germany. Good morning, dear colleagues. Soon, namely starting from August 17th of 2015, in part of the EU member states, this new succession regulation will be applied in practice. And my task today is to summarize and give an overview on what takes place currently in matters of succession and the field of succession in Latvia, Lithuania, Estonia, Germany, and Austria. Considering the fact that representatives from these countries are here today, please understand that I will not be so arrogant to think that I will tell Lithuanians what is taking place in Lithuania and tell Estonians what is the current state of affairs in Estonia. So if I say something incorrectly, then please take the liberty of correcting me in order for us to better understand how things are taking place in one member state or another. And we know that discussions are still taking place. As Mr. Virko said, the legislator and the institutions are still discussing and pondering things. I think that the insight that I'm going to provide you with during my speech will serve as a basis for discussions. In any case, we need to have a slight insight into how things are taking place in our neighboring countries as well as in our counseling countries, so to speak, namely Germany and Austria. So the first part of my presentation could be the institution competent for handling succession matters. So as you see, the institutions, three institutions can exist in terms of settling succession matters. For example, notaries handle matters of succession in Latvia, Estonia, and Lithuania. Courts handle these cases in Germany, and in Austria, these are notaries authorized on behalf of the court. In Germany, this process takes place more or less automatically, and it doesn't depend so much on the heir's activity as opposed to the situation here in Latvia as well as in our neighboring states, Estonia and Lithuania. In Austria, succession procedures take place through court proceedings, which are launched automatically by the court, whose jurisdiction is the deceased person's area of residence or habitual residence upon the receipt of a notification of the corresponding person's death. The same applies in Germany, and in Lithuania, handling of succession cases falls under the competence of notaries. And in Latvia and Estonia, notaries settle or handle succession cases according to the last habitual residence of the deceased person. Now, as for law applicable to succession, well, they tend to differ from one country to another. They might depend on the citizenship of the testator, or the habitual residence of the testator, or finally, as in the case of Latvia, according to the estate location of the of the succession. In Austria, the law applicable to succession depends on the deceased person's citizenship at the moment of his or her death. The law applicable to succession is the law of the country whose citizen the deceased was at the time of death, and Austria does not provide for any exceptions. Likewise, in Germany, the applicable law is principally defined by the deceased person's citizenship. And if the deceased is a foreigner, then one must verify what law would be applicable in his or her home country, and only then the law must be applied correspondingly in Germany. Besides, all foreigners can choose German law as the law to be applied for real estate located in Germany. In Lithuania, in turn, the matter depends on the habitual residence, the last habitual residence of the deceased at the moment of his or her death. The succession of immovable estate is defined by the location of the estate, and the Lithuanian laws do not provide an opportunity to choose another applicable law of another country. In Estonia, the laws where the last habitual residence of the deceased person was at the time of his or her death should be applied. However, in Estonia, the law provides the opportunity to also choose the applicable law to the matter of succession in question. However, certain restrictions exist. Namely, the testator can choose, as we heard from Edwards in his or her disposition of property, to choose the law of the country, the citizen of which the testator is, not the law of a third country. In Latvia, the law applicable to succession is determined by the location of the movable and or immovable property in question, and the law where the movable and immovable property was located in at the deceased person's time of death is applied to succession. Latvian laws do not permit any exceptions regarding this principle, which means that individuals cannot choose the law applicable to succession. The next part of my presentation will involve a brief oversight into intestate succession regarding the substantial norms according to which succession takes place in case the deceased person has left no will. I will not provide you with an in-depth overview because that would require a lot of time, and I think that this part should require a discussion regarding the particular state of affairs as it is in each of the countries mentioned. In Austria, the succession takes place depending on the closeness of the relation to the testator. Well, the spouse is certainly an heir, and he or she receives 1/3 of the succession, whereas the remainder is equally split up between children. If we look at Germany, then also depends, the succession depends on the closeness of the relationship, and the surviving spouse will be only one of the heirs who, together with children and others, will split up the succession to be inherited. In Germany, the share of the spouse's share to be inherited will depend on their matrimonial property regime. For example, if they have had property split up into equal shares, then the surviving spouse will receive 1/2 of the succession, whereas he or she will receive 1/4 in the shape of an intestate succession, and another 1/4 as a compensation. Which is paid one-off, and the remainder of the property is split up equally between children. In Lithuania, equal share heirs in the event of intestate succession are as follows. 6 categories of relationships and the surviving spouse inherits together with the first category heirs, namely the deceased person's children, and if, especially this takes place if the children are less than 3 in amount. If they are more, then the spouse inherits in the same shares as the spouse. If the first category heirs do not exist, then this goes over to the second category. If that doesn't exist, then the spouse inherits everything. In Estonia, if the deceased leaves no valid will or agreement, then the succession takes place in accordance with the law, which provides that relatives inherit in 3 steps, and the deceased person's spouse inherits along with the relatives. And in Latvia, people inherit in accordance with similar categories, and the surviving spouse receives the share of children if the children are not larger than 3 in amount, and if they are more than 3, then only 1/4. If the testator has no descending relatives, then the spouse receives 1/2 of the succession, and the civil law also provides that the surviving spouse receives the apartment and etc. Now, as for the testate succession, all of the mentioned countries have slightly varying requirements regarding to the form of the testate succession. In Austria, 3 types of wills may exist. Firstly, these are authentic wills drafted by notaries or courts. Secondly, these might be holographic wills, which must be completely written by hand and signed by the testator. And thirdly, these might be written wills. They might not be executed by the testator, him or herself. However, they must be signed in the presence of at least 3 witnesses. Likewise, in Austria, the reserved share is provided. It is half of the succession for the children, and the surviving spouse also receives 1/2. In Germany, also 3 types of wills exist. The first one is the authentic or the public will, which is executed in writing and certified by a notary. Secondly, this might be a holographic will written by the testator and signed by the testator, him or herself. And thirdly, this might be a will executed by the testator, him or herself, which the testator has requested to deliver it for keeping, storing at a court. Also, joint wills can be executed. However, it is indicated that these types of wills can be executed only by married couples or same-sex couples which have registered their relationships officially. Also, the reserved share principle exists in Germany, and it provides that the surviving spouse as well as children receive the succession. If no children exist, then ascending relatives receive the succession. Lithuania distinguishes two forms of wills. Firstly, these are authentic wills, executed in writing in 2 copies and certified by a notary. And the second is the holographic will, which is drafted by the testator and signed by the testator, him or herself. Similarly, as to Germany, children as well as the surviving spouse may request one half of the succession as their reserved shares if this has not been provided in the will. 4 types of wills exist in Estonia. Firstly, these are authentic wills drafted and certified by notaries. Secondly, these might be wills executed by testators and deposited at a notary's office. Thirdly, wills signed in the presence of witnesses by the testator at home. And fourthly, these might be holographic wills. Regarding Estonia, it seemed very interesting and topical the fact that this holographic type of will, as well as the private will, is valid only for 6 months after executing them if the testator is still alive. If the 6-month period expires, then the will is no longer valid. After the expiry of this period, a new will has to be executed, whereas for the first 2 types of wills, the authentic wills and the wills executed and deposited at the notary's office have no term of expiry. Latvian law also has several types of wills, authentic ones, certified by notaries or custody courts in case there are no notaries in the region in question. Secondly, these might be holographic or private wills, which must be completely written and signed by the testator. Or thirdly, wills executed by the testator and deposited at a notary's office or custody court, or handwritten or printed wills executed in the presence of 2 witnesses. And this type of a will be deleted from the civil law of the Republic of Latvia as of the 1st of July this year. So how do you become an heir? In Austria, the court orders are necessary in order to give succession to heirs. These court orders are issued after completing a special procedure, and the procedure is carried out by a notary on behalf of the court. The court, upon the receipt of the death fact of the person in question, launches a certain procedure, and the notary, being the representative of a court, represents the court and handles the care. The process is finished by means of a court order, by executing a court order. In Germany, succession after the testator's death takes place automatically, and heirs do not need to carry out any activities or initiative. However, if heirs wish to decline or waive succession, then they have to carry out an activity. So, in other words, you don't have to carry out any activity or initiative to accept the will, but you have to carry out an activity to resign one. And generally, the determined time restriction for waiving a succession is 6 weeks and 6 months, if inter alia the testator's last habitual residence was in another country. In order to receive a succession in Lithuania, heirs must be active. They must submit succession claims regarding the acceptance of a succession, or must start managing their property to be inherited. And this must take place within 3 months. And if they exceed this time frame, then they must submit a request at the court to extend this period. In Estonia, similarly to other countries, heirs may accept or waive exception. One has to waive a succession, otherwise it is assumed that the succession is accepted, and this must take place within 3 months. After the period, the heir has found out that he or she has become an heir. In Latvia, heirs have to carry out activities in order to inherit. The notary launches the case after he or she receives a claim for succession according to the last declared habitual residence. If the last habitual residence is unknown, the case must be launched according to location of the inheritable property or its main part. The period for accepting a succession is 1 year after the death of the deceased person, the testator. However, according to a request of an heir, the notary may determine another period which cannot be shorter than 3 months after announcing or placing an ad in the official newspaper Latvijas Vēstnesis. So, what can we conclude? Many similarities and many differences exist. I wish us all luck in coordinating and harmonizing these norms and working ahead. Thank you.
Paldies! Paldies, Ilzei!
Thank you to Ilze. As we heard, a good basis or a good ground have been laid for the second part of the seminar, when there will be cases to be examined, and each and every panelist from each and every country will be made available to express themselves for the discussions. And now I would like to give the floor to our guests from Vienna, Dr. Christoph Beer, who will outline an overview of the implementation of the regulation and its problems from the Austrian perspective. Mr. Beer is also a professor in Vienna, the university, and he plays the piano. We have many notaries involved or engaged in musical activities. So, the floor is yours.
Sehr geehrte Frau Präsidentin, sehr geehrte Damen und Herren, liebe Kolleginnen und Kollegen, ich habe zunächst eine gute Nachricht.
Ladies and gentlemen, colleagues, I'll start with the positive or good news. Taking into account
kann ich die Hälfte meines Referates
very good
und ich werde mich daher
very good presentation of the previous presenter, namely Ms. Metuzale. I can cross out or omit about 1/2 of my presentation. That's why I'll very pragmatically outline the main questions or problems of succession in Austria, and I will touch upon practical questions that we handle on a daily basis in our country. And starting from August next year might complicate your lives as well, so you might be interested in whatever I will say. The Austrian succession matters have been outlined very well, and I will tell to interpreters that I will switch from one slide to another of my presentation. In Austria, it is divided. The succession matters are divided. First of all, the heir to heir applies all the legal rights. And when succession occurs, he either is entitled to all of estate or to part of it, namely 1/3 automatically or reserved, and then 2/3 to be litigated. And then there are legators. To them, only part of the whole estate is applied, and they can ask only for a part of testator's estate. They have only reserved share of estate. We speak about so-called damnation rights in German. The speaker is saying in German. Those who do have rights only to part of the estate, so I mean indirect heirs, they have rights only to a reserved share, but those who do have rights to automatic rights, their rights are granted automatically. If a notary fills out or completes a will, he or she has to keep it, and there is a central registry of wills in Austria, and the registry in this registry is done by a notary, not a will itself is being registered, but a fact is being registered, namely noting a person who has signed the will. And in every case, this register is consulted to understand what was the will of the testator. Of course, in Austria, there are all kinds of agreements of presentation of shares, agreements of reserved shares, agreements of guaranteed shares. All those agreements or types of will are also registered in this registry. Now here you can see the legal order of succession. As I said, the spouse receives 1/3, children 2/3, unregistered partner doesn't receive anything. In this case, children receive everything. There you can see in this table to the right from the blue square. Now speaking about reserved share, you can see that the reserved share in Austria might be 1/2 of the total estate of a deceased person. In order to evaluate this reserved share, it is very often that an expert's opinion is needed. And now, some words about the procedure of the succession as such in Austria. This procedure is mandatory in order to receive succession. One has to fill out a form, a claim, so to say. In first cases, this person also takes up all the debts of the testator, but it's also possible not to take up all the financial burdens of the testator, but in this case also for evaluating the nuances or the amounts, an expert should be consulted. Speaking about succession matters and a court handling succession matters, the court is appointed by the location of the testator, so the regional court is the one responsible, and a notary is appointed by this regional court. So in Austria, it's called court's commissioner, but it's usually a notary. And at the end, this procedure contains an order for the conclusion of the succession, and ex lege, all the obligations and
und der Einantwortung
all the obligations are transferred to
der
an heir,
sogenannte ruhende
to the
Nachlass,
heir.
Hereditas
In between,
Jacens, welcher eine juristische
we have
Person
so-called
ist.
a
Die
peace
Verwaltung und
period,
Vertretung dieser juristischen
so-called peace
Person
period or
erfolgt durch
period of calm,
den oder die
when
Erben,
Heredita
wenn zum
Quiescen
gesamten
is
Nachlass
over,
Erbantrittserklärungen
as you can see from my
abgegeben
slide
wurden.
in Latin. And at this time, other applications for succession is
bewirkt die
accepted or
Einantwortung
are accepted if
den
there are
rechtlichen
several
Organ.
heirs.
Es erfolgt bei
And now about
Immobilien
this,
in der Folge die Eintragung
decision
im Grundbuch, die aber
about
lediglich
awarding
deklarativen
of
Charakter hat.
succession or inclusion
Im
into the
Gegensatz
succession.
dazu
First of all, there is a land
erwerben
registry,
Legatare
which is a
nur dann
declaratory
Eigentum
or
an
informative
Immobilien,
registry
wenn
or
ihr
character.
Eigentumsrecht
And
im
at the same
Grundbuch
time, or
eingetragen
in
wird.
different to
Zu diesem Zweck
heirs,
muss das
legataries
Verlassenschaftsgericht
do
eine sogenannte
have
Amtsbestätigung ausstellen,
rights to a share of
wofür
estate
allerdings die
if
Zustimmung
there
des Erben
is
erforderlich
a
ist.
note in the land
Mit der
registry
Amtsbestätigung
appointing
kann
or
dann beim
showing
Grundbuchgericht
that this
der
concrete
Antrag
legator
auf Einverleibung des
is
Eigentumsrechts
entitled to
für
this
den
estate,
Legatar
and the
gestellt werden.
person, the testator, has
Ganz kurz zur
appointed
Erbschaftssteuer.
a legator
Die gibt es in
to
Österreich
inherit
nicht.
this particular
Sie wurde im Jahre
estate
2008
that's been registered into the
aufgehoben.
land registry. And now speaking about
Lediglich beim Erwerb
a
von
particular thing that has
Immobilien,
been
fällt an eine Grunderwerbsteuer.
revoked in 2008, but it's nevertheless it's important. It was a special tax on immovable property, 2% for the direct relatives, otherwise 3.5% to all of others, plus 1.1% to courts as a procedural payment for the courts. So all in all, it's 3.1 or 4.6%. But what is important? The important thing is on which basis this tax is being calculated. And if we are speaking about inheritance or succession case within a family, then we can speak about a very small amount of tax or small burden of tax. Actually, I can say you can even not mention this tax that has to be paid. But if the succession is outside or involves people from outside the family, then there is a value added or a tax that's been added to market value of an estate, and 4.6% has to be paid. And it is tangibly more than within the in a succession within a family. And as I said, a notary is appointed by court. He's handling succession matters. He has all kinds of tasks. First of all, he finds out all the legal heirs, he asks information about different registries, gives information to heirs, he provides for
Das österreichische Verlassenschaftsverfahren ist
protection of interests of
als stark
heirs
anzusehen,
and their children, for
was
example.
den Vorteil hat, dass die Interessen der
At the same time,
Pflichtberechtigten und
a notary
Gläubiger sehr gut gewahrt
has
sind
to
und Rechtsstreitigkeiten
perform
eher
all
die Ausnahme sind.
other
Weitere
guarantees,
wichtige Konsequenz des
and
Verlassenschaftsverfahrens
especially think
ist,
about forced
dass im
heirs,
österreichischen
forced
Grundbuch
heirs,
nur
and,
erbrechtliche Urkunden
there,
verbucht werden, welche nach materieller Prüfung der Berechtigung
and their entitlements.
von einem Gericht
And according to the
ausgestellt
legislation of
werden.
Austria,
Das führt zu einer hohen
These entries
Sicherheit im
into
Grund.
land registry is
Das internationale Privatrecht
obligatory
und die inländische Gerichtsbarkeit
to be presented for courts for their decisions. If we are speaking about jurisdiction within a country, I must say that Ms. Metuzale has covered that. First of all, and the main thing is the nationality of a person, as well as
und inländisches bewegliches Vermögen
Austrian court has jurisdiction over immovable property and movable property that is located in Austria. Speaking about property abroad, it is necessary to fill in a certain form. But speaking about immovable property or real estate outside of Austria, these cases are not being handled in Austria. If a testator has not his habitual residence in Austria, but he has immovable property in Austria, then only things concerning this property that is located in Austria is being decided in Austria. But all the other matters concerning the succession of this person is not being handled in Austria. And now speaking about amendments or changes that we might face with entry into force of this regulation. First of all, a thing that has been already implied or imposed in Austria, and it is choice of law in Austria. Until now, this choice of law was not possible, was not being provided for. If I have filled in a will or written a will, then it's always has to be looked upon from an Austrian perspective, and only Austrian law can be applied to it. But if a testator lives in another country and dies in that country, and there is his or her last habitual residence, then there is a possibility of choice of law between this other habitual residence and Austria. So I have to say that the succession law of Austria might not be applied in many cases, and that's why I write this special clause in my will. As you can see, I, an Austrian citizen, applying the 22nd article of the regulation, so regardless of my place of residence or where I am at the moment of my death, my estate and my succession to my succession and to my estate, Austrian succession law should be applied. That's how I define it in my will. So this possibility of choice of law is not necessary at the moment because Article 83, paragraph 4, allows also for choice of law for wills that are made before 17th of August 2015. But at the same time, choice of law, of applicable law, becomes important only after the 17th of May 2015. But as we all know, that these changes do take time, Austrian notaries or Notariate of Austria suggested to its members to explicitly state the choice of applicable law also to wills that are being made right now. Also, I am obliged to inform a client, a foreign client, that he or she might express his will of application of another country's law in his will. In order to do so, I consult these homepages, web pages that you can see here. I consult them and I see what are the obligations of this other country whose law the person has chosen in order for us together to formulate this choice of law expressly. So I consult this homepage to do it in a correct manner. Also, I would like to mention another web page about couples in Europe, where the matrimonial property regime is being discussed. Also, I would like to say that there might be cases when a deceased person intentionally wishes to allow for several possibilities, or for the fact that I'm not making this choice of law, then it has to be done explicitly. First of all, to make sure that this has been done. Otherwise, there might be certain liabilities on the part of my direct heirs. So I would like to take the liberty of suggesting you to expressly show this choice of law, the choice of law of one or another country, or declination of this choice of law. Otherwise, there might be some legal issues or legal consequences.
That would be the case if the testator executes his or her will, for example, holographically, without knowing the applicable law to the necessary degree, and after that changing his or her place of habitual residence. Since the regulation does not provide for a concludant, then the choice of law might entail difficulties or problems. Thus, if a foreign citizen has left succession, then one must verify whether the choice in the favor of the citizenship country's law has been made. I would like to suggest or recommend informing clients about the fact that the choice of law should be changed only by means of drafting a new will or new disposition of property. And by making this change, the applicable law can be made. One must also consider that upon the execution of a will, if the previous will provided the choice of law, in the previous will provided for the choice of law, then the new one should do the same. And the same would apply with regard to the declination from the reserved share. And the same would also apply to gift agreements in the event of death, as well as the other types of reserved shares which are left to heirs before the testator's death. Another interesting aspect, particular aspect to Austria and possibly other member states of the EU, which provide or specify very detailed rights regarding the reserved shares of succession, will entail a discussion whether, for example, the immigration of wealthy heirs might take place to, say, southern England, and not because the weather is nice in Cornwall, but in order to be able to exercise English succession law, which specifies an only very limited share of the limited part of the reserved share. I don't think that Austrian seniors will voluntarily emigrate to England for this reason, but it is possible to identify other risks. For example, the Austrian law provides provides for the institution of an authorization of an advancement authorization. For example, in the case of incapacitation of a testator. And the heir can thus become the authorized person to start acting or start dealing with the estate according to the habitual residence. And this might be a basis for pondering whether the incapacitated authorizing testator to move to, say, Cornwall in order to decrease these reserved shares. However, if the succession provides for the choice of law of Austria, this will not be possible since day one. And most probably, no authorized persons will be able to carry out such kind of activities by means of moving the habitual residence to, say, England. Now, as for the validity period of a will, formally, we have to observe the Article 27 of the regulation in this regard. And it supplements the Convention of Hague regarding the validity of the successions. And in accordance with Article 75 of the regulation, the Hague Agreements on Successions takes priority prevails over the regulation. And we are going to review this in one of the cases that we will observe during the afternoon session. And in accordance with the transition provisions, the Article 83, paragraph 3 lays down that the corresponding law must be applied to the dispositions of property which had existed earlier. So we see this backward direction, backward effect. Article 27 provides sets forth a certain catalog characterizing to what extent the will is valid. And I would particularly like to outline clauses B, C, and D. And particularly, the discussion is about the relationships and their links between them and the country where the disposition of property had been executed in. The update or the recent development is the switch from the citizenship principle to the principal habitual residence element. And when reviewing matters of succession with regards to foreigners, Austrian succession law must be applied. However, one must always verify whether the choice of the corresponding applicable law has been observed. And this must also be verified with regard to the citizens of third countries. And now I have almost finished, and I'm certainly following the timing that I've been given. And the amendments to the land register law as well as commercial law, I would like to talk briefly about it. As I mentioned previously, both parties must have notarially certified signatures in order to be able to make entries into land books. This is also necessary with regard to the adoption of decisions for awarding successions to both heirs as well as legatees. Now certain changes will exist because Article 69, paragraph 5 lays down that the European Certificate of Succession is now an efficient or valid document in order for introducing the succession in question into the register. And my colleague, Mr. Dorsel, already addressed the provisions of the same article, paragraph 2, clause K, and the substantive rights as well as the numerous clauses exception. This involves legal preconditions for making entries into land books, and what are the effects if the entries are made or are not made, and what are the reasons for that. Also, recitals 18 and 19 were referred to in the previous presentations, and we see that several unclear matters exist in this regard. Now I would like to quote Kurt Rechner.
Seite 497. In der Praxis wird sich die Frage stellen, wie die österreichischen Grundbuchsgerichte
And I would like to recommend you read his article regarding the new European certificates of succession. Now, regarding certificates of succession issued abroad, which do not comply with the Austrian succession law. In Austria, substantive rights are highly structured, and in accordance with the existing legislation, the land register court can decline an entry in a land book if it questions the content or the right or the bona fide character of the person who wishes to make such an entry. Therefore, in doubtful cases, the land register court may request to provide legal statements which are necessary in order to verify a matter and to verify whether the certificate of succession in question is valid and is legal. This is necessary in order to verify whether the certificate of succession issued abroad is sufficient, or maybe something else or additionally is needed. Also, one must clarify whether certain entities have carried out changes or amendments on the basis of all of the members consent or approval that had to be taken into consideration. Now I would like to touch upon the matters that involve the European certificate of succession. Three cases or three directions should be distinguished. Firstly, this is a certificate which is issued for the estate manager or the executor of will. As I mentioned, as soon as heirs submit their claims regarding the receipt of a succession, the corresponding certificate of succession can be issued, but on the basis of the administrative law of Austria, this case may only permit the application of regular administrative provisions as opposed to the special ones. Considering the former description regarding what takes place during the procedure until the succession in question can be received. The certificate can be issued to an heir only when the order for the execution of will can be issued to the heir in question. Earlier, it wasn't possible in accordance with the Austrian succession law. And the last option is related to the legatee. In accordance with Article 69, paragraph 1. Article 63, paragraph 1. A certificate is issued to a legatee and it has a direct consequence on the legatee. The vindicative and damnation legatee must be mentioned in this regard. However, since Austrian succession law does not exercise the institution of the vindicative legatee, the certificate is not provided for in this case accordingly. If one must apply the law of a country, of a member state, which applies the principles of the vindicative legatee, say France, Spain, Poland, and so on, and if the legate is related to an estate in Germany, then the legatee cannot receive a certificate. In this case, the legatee must evidence the rights to the succession on the basis of documents issued in this country. For example, Austrian origin subjects should go to Germany and vice versa, and this is unacceptable. But the discussion might be about the receipt of these documents from the necessary authorities if, say, legatees go to the land registers, and they no longer have to evidence the additional facts and elements. There might be a discussion that in accordance with the documents issued, the legatee will receive an authorization in accordance with Article 63, paragraph 1.
Wir werden sehen, ob das so gehandhabt werden wird.
So the certificate of succession can be received on the basis of 63.1. Let's see whether that will work in practice. In Austria, it will always, the competent authority will be a court. But the question remains whether it will be a notary on behalf of the court or appointed by the court, because the question remains, because in 64b it states, as well as in recital 70, it states that it might be possible which can directly be applied to Austria, and let's see how it will work in practice. So I conclude my presentation on this note. I'm sorry for being too long, but not very, very long. So thank you very much. Thank you, Mr. Berg. Maybe it will come as a surprise, but we do have 10 minutes until lunch. It's the lunch will be served at 1:20, and now we do have time for questions, at least 1 to 2 questions, either to one of the speakers or representatives from different countries to one another. So this is the possibility for you to ask questions. We do have 3 microphones. We'll pass them on for the interpreters to interpret your questions and for everyone to hear you.
Jā, lūdzu celiet roku droši, kam pēc visa dzirdētā.
So after everything that you've heard, there are no questions. I doubt that.
Jā, būs jautājums, lūdzu.
There will be a question here.
Mantošanas regulas viens no
Speaking
svarīgākajiem
about this
jautājumiem ir jurisdikcijas
new
noteikšana.
regulation of succession, the main
Tomēr no
thing
iepriekšējiem
is the
runātājiem un
applicable
arī no
law.
regulas mēs
And from
konstatējam,
previous speakers,
tikai
as well
daļā
from the
valstis
regulation itself, we can
notāriem šī
understand that
jurisdikcija
notaries
būs jānosaka.
will be the ones
Jautājums,
who will determine the applicable law.
Varbūt tās
And the question is maybe to Mr. Beer and Mr. Dorsel, and maybe also to colleagues from Estonia and Lithuania, how does it work? Is it a notary who execute the functions of a course? And according to the regulation, whether a notary will be the one to determine the applicable law to the succession. As Mr. Virko has also pointed out that in Latvia it might be the case that a notary doesn't equal the word court. So if a legislator decides so, then I might say that always a national or law will be applied, Latvian law will be applied, and no other applicable law will be possible. So that's a question to Lithuania and Estonia, and also to Mr. Dorsel and Mr. Beer. How do you see this possibility of a notary to determine the applicable law? Thank you.
Paldies Gatim par ļoti vērtīgo jautājumu.
Thank you to Gatis for a very, very good question. And I will give the floor to
Vielen Dank für die Frage.
Mr. Beer. Thank you for the question. Speaking about German law,
Über die Frage, welche Behörde für die Antragstellung zuständig ist,
so the question in principle, who determines the applicable law? This question has to be looked upon separately from the question of who is the authority
Die Erteilung des
to
Nachweiszeugnisses wird aber in Deutschland
decide on succession as such. First of all, you can hand it in to court or to notaries, but according to German legislation, it will be the court who will determine the applicable legislation. What's the case in Austria? In Austria, this question is not entirely sure. The question is not answered, and the matter is not solved entirely. We can try and foresee that notaries will equal courts or will fulfill the obligations of a court. Notary is not separated from a court, but is an extension of a court or representative of a court in its full extent. And already now, Austrian law provides for that an application could be filed at notaries, and a notary will hand it further to a court, and regarding to possession, transfer of possession, the question remains. It is not clear who will do what will do court and what will do a notary, speaking about the transfer of the possession. Thank you.
Kas varētu no Igaunijas?
Who could speak on behalf of Lithuania and on behalf of Estonia? Please present yourself and tell us which country you are from. I am from Lithuania, and in Lithuania there are discussions now going on. The Ministry of Justice has not made up its mind. A notary is not equal to a court, so notary doesn't have this regulation as a binding regulation. And I would like to ask the colleagues from Germany and Austria, how should we do if the last habitual residence of a person was in Lithuania, but applicable law was not the Lithuanian law, but the German law, and how is that possible?
Vai varētu teikt, ka šis jautājums būs kāzusu risināšanas
So questions like this will be discussed in cases. Yes, cases exactly as you've just commented, you just come up with, will be the ones that will be discussed and solved during cause, the second part of cases. And now I will give the floor to Estonia, speaking about applicable law and who has jurisdiction over successions.
Juba täna on ainukeseks pärimismenetluse läbiviijaks notar ja ta teeb seda siis algusest lõpuni. Notarile väljastatakse või antakse avaldus menetluse läbiviimiseks ja notar siis selle menetlusega lõpetab ja väljastab pärimistunnistuse.
In Estonia, the notaries are the only ones who tackle this case from the beginning to the A, and notaries will be the ones who prepare and issue these certificates. In general, the succession procedure in Estonia is can be compared to a procedure which contains no elements of claim lodging, and notaries are perceived as representatives or extensions of the courts. It is considered that legislation must be changed, and we have made the according steps and started preparing for that.
Siis on küsitav, et kas me ikka saame öelda,
Notaries will be obliged, they will have the duty to issue these certificates. However, it isn't so that currently they have to base their activity on the regulation. Article 64 lays down that the institutions that are entitled to issue certificates are regulated to do so or are permitted to do so in accordance with Article 4, 7, 10, and 11.
pädevus ja õigus seda asja menetleda on juba hilja. See on küsitav, et nüüd ei pea vaatama siis
In order to determine whether, in accordance with these provisions,
määruse kohtualluvuse sätteid.
this case, the certificates must be issued, it will be too late to decide what the corresponding authority is and what it should do. One must keep in mind, however, that the regulation must be implemented in a direct manner, which means that the citizens of the EU have the right to claim or demand the observance of their rights in accordance with the regulation, which this regulation lays down. And notaries cannot say that they will not do this or that because they don't want to. I think that we will have to work in accordance with the regulation, firstly and foremost.